We now want to bring in some experts we've been talking to this whole entire trial. Joining us right now is Tonya Krause-Phelan, Andrew Rodenhouse. Tonya, Andrew, thank you so much for joining us. I just want to start right off the bat. We just heard closing arguments for both sides and the rebuttal. Kind of talk about what's going through your head. What really stuck out with these closing arguments? Andrew, I'll start with you.
Well, I don't. First of all, I thought both parties did a good job presenting what their case was and making closing argument about what they thought they had established, and that's the point of a closing argument. As part of the jury instructions, they're instructed that what the lawyers argue is not evidence, and that they're only to consider the evidence as it was given to them through the witnesses and by the court. But I thought both parties did a good job summarizing what they believe the evidence established. I thought Mr. Bergola did a nice job of explaining how the lesser included, that they still have to prove that it was without justification, even on the lesser included of the manslaughter. I know the question is going to come that what is manslaughter? Well, I'm going to pass to my professor who taught exactly that in law school, because there's about 15 different varieties of manslaughter, and I'm thinking they're just getting a simple voluntary manslaughter instruction.
Yeah, Tana, if you could just jump in and kind of explain to us what voluntary manslaughter is. We too try to look up the definition of it and multiple came up. So we just want to, if at least for this case, kind of help people understand what this second charge is.
Sure. And I want to just go to your first question first. And I agree that the lawyers were very consistent in their closing arguments with the theory of their case. We've talked at the beginning of this trial about how opening statements, the lawyers can't argue. They simply can say what they think the evidence is going to be throughout the trial. But when you hit the closing argument, now the lawyers really get to come in and they get to say, this piece of evidence means this because. You hear a lot of because statements, and that's what we mean by argument. And the argument was consistent with what we saw them develop in opening statement and through the questioning of all their witnesses throughout the case. So in that respect, both sides did a really nice job with their closing arguments. With respect to voluntary manslaughter, it is a less serious form of homicide. Now, as I understand it, the defense objected to the voluntary manslaughter instruction being given to the jury. And the reason I anticipate the defense objected is because now there's sort of a middle ground for the jury to hang their hat on, right? We call it a compromise verdict. And that could, if jurors compromise, if some are saying, gee, I think it's second degree murder, and some jurors during deliberation are saying, hey, I think he's not guilty because it was self-defense, they can maybe bridge that gap and all settle on manslaughter so that they don't result in a hung jury, meaning the jury could reach a verdict. So I anticipate that's why the defense didn't want it. And I anticipate that's exactly why Prosecutor Becker wanted that lesser included instruction. So, manslaughter, as I said, is a less serious form of homicide. And homicide simply means an unlawful killing of one human being by another. So, as we've talked all along, second degree murder, just a reminder for the audience, the prosecutor had to prove that Mr. Schurr caused Mr. Lyoya's death, um, that he did so with malice, intent to kill, and that it was not justified, meaning it was not lawful self-defense in this particular case. Now, manslaughter, if they just gave the simple manslaughter instruction, that means it's a less serious form of homicide. But there's also this idea of manslaughter that it can be a result of heat of passion, right? That there was some kind of provocation that caused Mr. Schurr to act in that passion instead of cold-blooded murder. We're talking about passion and that he responded to that passion before he had time to cool off. And that's typically what we mean by voluntary manslaughter. That's one of the most common forms of voluntary manslaughter.
Can you maybe talk about how that can complicate things, or does it? I mean, this whole trial we have been watching for a second-degree murder charge. Now this new charge comes in. To me, I'm now no expert, just a normal person who would think, okay, now I have to think about this case completely different. And also, the defense and prosecution has been arguing on a second-degree murder charge. To me, it kind of almost seems like the defense didn't get a chance. I mean, they did in their closing, but a chance to really kind of argue that as well. Kind of talk about that.
Sure. And, as was already pointed out, even with a voluntary manslaughter charge, the prosecutor still has the burden to prove that it wasn't justified. So I want to make sure that that's clear to the audience. But you're exactly right that it could confuse the jurors because they didn't hear anything about manslaughter at the beginning of this case. Remember, judges give instructions at the beginning of the case as well, and they read the charges to the jury. They tell the jury what the defendant is charged with, and that was never mentioned. So it can raise confusion with the jurors. And so that's where this idea of a compromise verdict comes in, right? Where if you have some jurors who think, hey, he's guilty of second-degree murder, and others thinking, no, he's not guilty because he acted in lawful self-defense and therefore the killing was justified, they can kind of come to the middle ground and vote on that voluntary manslaughter charge. Now, when the jury goes back into the deliberation room, they will be given a verdict form. And if Judge Mims is consistent with how most judges in Kent County operate, the first thing that will be on that jury verdict is that we, the jury, find the defendant guilty of, and they list the most serious charge, second-degree murder, and they'll be allowed to say guilty or not guilty. Then they'll see the voluntary manslaughter charge and can vote guilty or not guilty. And then there will be the not guilty line if they completely find him not guilty and acquit him. So now there's this middle charge, right? That's going to rest between second-degree murder and not guilty when they go into that jury room. But before they can reach a final verdict, they're supposed to deliberate on all charges presented on the verdict form.
Andrew, I'd love to hear your take on this. You actually talked to us earlier and said that you thought that this possibly could happen. We now have seen it happen. I guess, what is your reaction to now this being in play for this trial?
Well, I exactly agree. The problem is that when you get into that jury room, and I've had this on multiple times, where if you've got a compromise place where people can land, they will often land there. It's called, in politics, we call it log rolling. So you might have jurors that are like completely not guilty on everything, and jurors that are completely guilty of second degree, and they want to try to resolve the case. And oftentimes you see it play out on a Friday afternoon about 4 o'clock, and all of a sudden they land on the guilty on the lesser included, and it just feels like it's, I don't see how either side is happy with that. But I think Mr. Borgola pointed it out. Like, look, this even if you're considering it, it's still a complete defense. And I think Mr. Becker was asking for it because he's like, well, even if I didn't prove that he intended to kill him, that he intended to cause him great bodily harm, and he wasn't justified in causing him great bodily harm. This is the type of thing, again, like with the experts, that the Court of Appeals will have an issue with this if they think it was given in error or over the party's objection. And so these are the types of things that, if there is a conviction, could put the conviction in jeopardy at the Court of Appeals. But let's let the jury play this out. I think it's important for the jury to deliberate. They've got the case now. Finally, we got through the whole trial. I'm pretty sure everyone is exhausted, and now they want to have the jury do what the juries do, which is deliberate. Now, the first thing they have to do, and they might not want to start right away. They might actually decide they want to go get lunch. And so that's pretty typical when a case is given to the jury just around noontime or around 12:30. They will oftentimes decide that they want to go to lunch first and then come back to deliberate. And so it could be fast, or I've had jury deliberations that have taken up to a week. So who knows? Nobody knows. And it's just one of those things that they teach us in law school, patience, by not giving us our grades right away. And so we have to just wait patiently.
And you brought up something that I was going to ask you about, which was the appeal. If there is an appeal after, and before, from what our knowledge was, is that that appeal will be focused on that second-degree murder charge. If for whatever reason they decide to convict Schurr on the manslaughter charge, does the whole entire trial that hasn't been focused on that charge, does it go out the window? I guess, does that complicate the appeal process? Because to me, it just seems like it just scatterbrains it.
It could, and that it determines on how the jury deliberations return. If they find him not guilty of the second degree and they find him guilty of the lesser included of manslaughter and the case gets reversed, well, he's already got jeopardy attached to the murder too, and so they would have to retry him solely on the manslaughter, and so potentially if the jury comes back as the second degree and then it's reversed, then he would only, excuse me, rephrase that. If the jury acquits him of the second degree and then moves on to the manslaughter and convicts him of the manslaughter, if it's reversed, then it would come back and the trial would be on just the manslaughter.
So potentially we could have a whole nother trial if that happens.
Potentially, it happens often enough where, well, I mean, I think Harvey Weinstein is having his trial this week too. So it happens across the country where large, high-profile cases are reversed, and you just have to try them again.
Tonya, I want to bring you in to kind of talk about some of the things that stuck out to me when the judge was talking about the instructions for the jury. She honed in on deciding the trial based on the facts. And she talked about how saying what lawyers will say are not facts, or the questions that they might have asked and those answers are not facts. Can you kind of explain the importance of that? Because I think when we hear a trial like this, we're like, oh my gosh, so much was said. They had to focus on those words, but it's actually very specific on what the jury is actually looking at.
Yes, and it's a very common it's a standard instruction, as a matter of fact, that what the lawyers say throughout the case in their opening statements and closing arguments is not evidence. And a few days ago, I was talking about the idea that lawyers cannot be advocates and witnesses in the same case. So evidence in a trial comes in through physical documents and exhibits and what the witnesses testify to. And the jurors are limited to considering only those things. Sometimes there'll be stipulated facts, but they're limited to those things that have been received by the court as evidence in the case. So it's very common in both the preliminary instructions before a trial starts and in the final instructions just before deliberations begin for the judge to remind jurors that, look, what the lawyers say is not evidence. Our opening statements and closing arguments are tools that we use as advocates to sort of guide the jurors where we want them to go and how we want them to interpret and find the facts. But at the end of the day, it's not evidence. And it's also important in this particular case because it took 3 years to get to trial, right? And in that time, there has been a lot of outside discussion about this case, including from the civil lawyers who have been talking quite a bit to the media over the course of 3 years. So the judge wants to make sure that the jurors are not, that they have blinders on, if you will, and that they're not considering any of the stuff that's going on outside of the courtroom when they go back into that jury room and deliberate.
And you bring up the civil case, which is something that we have talked to Ben Johnson about. He's representing the family in that civil case. For people who maybe will get confused, can you just help us understand that a criminal trial and a civil trial aren't connected and the outcomes can be very different?
It's exactly right. There's a whole, crimes are charged as wrongs against the community, right? We have a code of conduct as members of a community that we agree to live by. Those are the criminal laws. They tell us what we can do and what we can't do. And so when a person is accused of committing a crime, that's why they're prosecuted by a government official. When we look at the civil cases, those are private cases between one party and another, where they're saying, you wronged me, or in this case, you wronged my deceased family member and committed a private harm against him. And so that will be a tortious type of claim. And if there is a finding of responsibility in the civil case, then monetary damages will be awarded. When someone is found guilty of a crime, there's no money paid unless it's restitution, but the consequence of finding of guilt is the possibility of incarceration. So two very different issues are being litigated in a criminal case versus a civil case.
Andrew, I just want to jump back to you really quickly. I know that you just said this, but just so we're all clarified on this situation, if Schurr is convicted of manslaughter and the appeal finds that he wasn't, then there is the retrial. He has to be first convicted, then the appeal has to go through, and then there's a retrial. Am I understanding that correctly?
Yeah, and let me just explain how it starts with the jury verdict form. And so on the jury verdict form, they'll be instructed to make a determination on murder in the second degree first. And so the first thing they need to do is deliberate whether or not the prosecution proved beyond a reasonable doubt that Mr. Schurr was not justified and that he did in fact intentionally kill Patrick. And if they did that, then they will find him guilty of second degree murder, and then they won't deliberate whether or not there was the lesser included, because then they will be done. But if they find that he's not guilty on the second degree, and then they move on to deliberate on the lesser included of manslaughter, and if they do find guilt on manslaughter, because he was already acquitted of the second degree murder, jeopardy attaches. And in the United States and Michigan, you cannot be tried twice for the same crime if you're acquitted. And so if it's reversed on appeal, he will already have been acquitted of the second degree murder, and any retrial, if there is a retrial, and that's a long ways away, and that's a lot of ifs, but if you do end up in that spot, then the retrial would be on the lesser included of manslaughter.
And we're going to be wrapping up our coverage pretty soon, but I just want to get both of you all's final thoughts on this trial and where we are at this point in the trial. I'll start with you, Andrew.
Well, I'm happy that this trial has been gotten to the jury. I think it's important for the community to understand that this is a whole process, that if Mr. Schurr is acquitted, that he was afforded due process, that the community was able to see, hear all the evidence, and that it was fair. And if he's convicted of something, I want everyone to understand the same, that this is a process and that there is more things down the road, and he has more process rights down the road. And so the big takeaway is that this was a big case for the community, and it was nice for me personally as a lawyer to see how the judicial process play out in public, where people can see like what it actually is like in the courtroom.
And Tonya, I'd love to hear from you as well.
I totally agree with everything that Andrew just said. And one thing I think also is important for the viewers to consider as now the deliberations play out is there's no way to know how long the jurors will deliberate. Jurors might come back really quickly, or they might take several days to go through this. And if at some point during the deliberations, the jurors can't reach a consensus, they may actually come out to the judge and say, hey, we're split, we can't agree. And judges normally, the first time a jury does that, in any case, the judge usually will say, hey, we get that this is difficult, but you heard the testimony, you saw the evidence, it's your responsibility to go back and continue deliberating with respect and due diligence and try to reach a verdict. So that could possibly happen. I mean, there's a whole spectrum here of quick verdict, long verdict, or the jurors struggling throughout the process. And there are no tea leaves to be read there, right? There are absolutely no tea leaves to be read there. Any of those outcomes is normal because every criminal case is different.
And just for those who might not know, is it a majority that has to come to an agreement? Is it unanimous? What's in this case?
In criminal cases, the verdict must be unanimous.
All right. Well, thank you, Tonya and Andrew, for joining us. I would say that this is over, but clearly it's not. We still have deliberations still happening right now, so we will be checking in with you once we get that verdict. We're now going to conclude our stream at this time. We're doing this because, as you know, jury deliberations are not on a set time. and can even take days to come back with a verdict. We will be informed by the court as soon as possible when that verdict is reached, and we'll be live on 13 Plus as soon as the verdict is reached. In the meantime, you can watch days of coverage on demand on 13 Plus and read more online at 13onyourside.com and catch up on our live blog, which breaks down all the testimony across 6 days. We'll see you right back here on 13 Plus when that verdict is reached.